Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello, everybody. Mike, I'm glad to see you. I hope you're staying safe. I've been watching the storm coverage, lamenting. It's also raining here. Obviously, not as bad. You can just shut the fuck up about it, Paisley, honestly. But I am going to be going out in my own storm and going to the gym later on. Woohoo, Paisley. If you missed it, you guys, I made sushi earlier today. It actually turned out really well, and you should take this as your sign to make some sushi as well. Also, you may hear my voice sounds a little bit persnickety. I personally think that this is specifically because earlier today, I made a cheap shot at Ryan Hall, y'all, about losing his voice. I was like, I mean, I said it to myself, so obviously I don't know if it's the devil or God or whoever is in charge of that shit, but I said to myself, I was like, losing his voice. I mean, I've done 9-hour streams before. I mean, it's just talking. I don't think it seems like a big deal. And then literally within hours, my voice started to go. And I was like, well, karma is a bitch, isn't it? It really fucking is. So, oh, he's making bank with Super Chat. Max Velocity's making bank with Super Chats. They're all, I've seen a channel get 100,000 subs in the last day. All the power to them. I didn't fix my eyebrows. Ugh. Whatever. Hurricane brows. Anyways, I did see somebody getting mad about the money. I just laughed. I'm like, but you're here. You're still here. Anyways, so let's hope that my voice doesn't go away completely. I imagine if I laid off the weed a little bit, that would help. But we all know that's not going to happen. Plus, I can get codeine over the counter here in Canada. So, worst case scenario. Or worst case Ontario, as we say here. We do have some court to watch today. Yes, we do, indeedy. Where the fuck did I put it? There. Courtney's okay? Good. Good, good, good. I've been worried about you guys. Worried about you. Well, like last night, this guy, he got $500 super chat from somebody. First of all, I would probably lose my mind. Okay? And then secondly, he reached 500,000 subs and he was so quiet. I was just like, bruh. Like, come on. That's a big milestone. You gotta like...
in 24. Okay.
know when to... whatever the words are. Oh, ma'am.
Hey, Jennifer, we do not have lyric.
Hold on. We do not have lyric. We do not have...
In our waiting room.
Okay.
Calling case 2018-1701DS, Lyric Cannon versus Tevin Wines. Today is Monday, October 7th, 2024 at 9:41 a.m.
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to show cause. And the defendant is not present.
Defendant is not present.
Okay. Ms. Reed, as I go through the motion, I think obviously is well taken. The court would order I'm going to, if the defendant was here, I'd order the produce paperwork within 7 days, but being that you're gonna have to submit it and it's gonna be after, again, the 7 days, it doesn't make sense to do that. What will happen is the court will state that order the defendant to produce the most recent paycheck stub within 14 days of today's date, that he also be ordered to set up the Our Family Wizard within 14 days, and the court will grant your request for attorney fees of $700, which shall be paid within 45 days of today's date. You can submit that order under 7 days.
All right, thank you.
Thank you. You have a good day.
You too.
Myrick, we do not have plaintiff Joy Jones in my waiting room.
I had to
Please
focus this
unmute,
morning.
Cameron.
Yes, ma'am, I couldn't hear you.
That's okay. Calling case 2007-3970 DS, Joy Jones versus Cameron Myrick. Today is Monday, October 7th, 2024 at 9:43 a.m.
Court will note that this matter.
Actually, can the court note something for me? I need you guys to do me an experiment. My Amazon wish list is in the link tree. If you guys, do you get Amazon deals today? And do they apply to somebody else's list? This is the question. I added some new tops and some new cute things today, but I just wonder. If that works like that. Christopher has more coffee coming for me, thank goodness. But I also put a travel coffee maker on there because I want to travel again, and I don't think I can travel without my coffee anymore. I sound like my mother. That makes me sad. All right, Judge. Back at you. Also, I'm going to blame the sugar-free Red Bull for my voice. I've never drank these. Y'all know I love my fucking sugar. These were bought for me incorrectly by somebody. And none of you, just so you know, I'm not mad at anybody here. But I believe that it is whatever is in here that's sugar-free. What is it? What have they put in? Sucralose. It's the sucralose. I'm blaming the sucralose. Because I smoke weed all the time. That doesn't make my voice go away. It just doesn't. It's got to be the only thing that's changed. John, you should check out my Amazon wish list. It is hilarious. There's some specialty items I have on there, like McDonald's purses. They're really funny. All right, let's go.
Before the court on the defendant's motion to set aside the referee order in this particular matter. Mr. Myrick, as I looked through the file, you stated that you had not received the paperwork for the hearing on September 4, 2024, but that paperwork was sent to your address, which is the same address that you filed with your motion.
No, sir. I was talking about the first letter that they mailed off. I think it was either May 5th or June 5th. They sent out a first letter to let me know about the review. And
How do you know about it if you didn't get it? Question. Canadian conversion, some of the things are weird, like they cost $32.67, they don't end in 99 or 0. Yeah, that's normal. Not everything in America ends in 99 cents, right? Our pricing is pretty across the board. At Costco, shut up. What the price is tells you if they're gonna order it again. Like if it ends in a 6 something or other, there's an asterisk on it, then they're not getting that product back. Something like that. I used to be a Costco genius. I don't go there anymore. But let's see here. Yeah. Oh, that's what I was gonna say. I ordered. What did I order? I personally ordered 2 items. I can't. My orders. So I got this like a bracelet for my Fitbit, and this thing. Oh, I guess the price was $9.99. Anyways, that price was $9.99. Oh, I'm sorry that you didn't know that Amazon was having a thing. They've been advertising all over. Anyways, I don't know why I was getting off on that tangent. Let's go. Oh, Courtney messaged me. I think she's good. You guys said she is, but I'm confirmed.
It also stated in there that my daughter was not going to be with her mom. She was going to be with her grandmother because Joy said she ran away to her mother's house and didn't come home. And so it also stated that I didn't object to that. And so I was never given the opportunity to object to her even being at her grandmother's house, because she could have came and stayed with me. And so they sent that to 1631 Gresham Road, apartment D, as in David. They sent that letter to that address. And so I didn't even get proper understanding of what was going on until the second letter came. And the second letter came, I want to say it was like July 3rd. And during that time, I only had until the 4th of July to have that turned in, or I would have been forfeited from not being able to speak up for myself in this matter.
Okay.
Yes, sir.
Okay. Well, what you're gonna need to do, sir, in any event, you're gonna have to file a motion either to change custody and or parenting time, or both. And you'll have to allege proper cause, change of circumstances, and file that motion, notice it up, and then the court will hear your motion at that time, okay?
Can I ask you a question?
Sure.
So when I did get the mail, it told me that the hearing with referee Snyder was going to be about the parenting time and the review. So I did try to talk to him about that, the parenting time, and he also told me about getting custody. My daughter will be 18 years old in less than 3 months.
Okay, so it's a moot point then.
Sir?
Yes.
No, I didn't hear you. I'm sorry.
I said it's a moot point then if she's going to be 18, because the court has no jurisdiction over her after she's 18. And it would take you, if you file your motion, schedule a hearing, it's not going to be done probably until close to that 3 months anyway.
So, yes, sir. And so I was hoping to have some type of parenting time before she turned 18, so they wouldn't not give it to me. Over the past, since 2008, when I moved to Georgia, I've always been very communicative with the court and with my daughter mom, and she has never allowed my daughter to come see me. And
Okay.
so until I started going through this right here, I didn't know I could do all of this stuff by myself. So that was proper uneducation on my behalf.
Yeah.
But I thought I would have to pay for a lawyer, and I wasn't in a situation where I could pay for a lawyer, so I never had the chance to do it.
You can file a motion for parenting time, not the motion to set aside the referee. That's not the proper motion. You can file a motion for parenting time, setting forth the factual basis for doing so, and then the court will consider that. But quite frankly, in this particular matter, again, it's a matter of what at your daughter at her age, she's almost 18, so she's gonna have the say-so on that. It's a matter of, does she wish to come or does she not wish to come and stay with you? I have no idea. I won't know until the motion would be filed. You have a right to file a motion. That's up to you, but you have to consider what your daughter is gonna want to do as well.
Yes, sir. That's understandable.
Okay, okay, go ahead, you can file that and the court will hear it at that time.
Okay, and so a part of the objection also was, so when I talked to referee Snyder, he also seen that I didn't get any credit for my 5 kids, which 4 is actually with me. My other 5th child, she graduated high school in May, so I'm almost done with her child support order, and she's in college right now, going to school to be a psychiatrist.
Yeah.
And so whenever they estimated how much money that I gross every month, that was an inaccurate number because, like I told referee Snyder, I work for FedEx, and so everybody reads the news as far as, this being an election year, and the amount of freight that's actually going through the system is not the same. And so this number that they've calculated on me making every month is not an accurate number to be able to give an accurate amount of how much I can actually pay a month. I also told them in the review and with referee Snyder that, me and my wife have 3 kids and 2 of our kids are twins and they have a disability. And so I don't qualify for Medicaid. And so my insurance only covers a certain amount of money. And with the ABA and the therapies, that's like $150 a week that we have to pay with co-pays just for them to have the therapies that they need.
Yep, put all of that in your motion, sir, and then file it and we'll address it.
Well, it's in the motion, sir. It's in there.
Well, it's not in the motion before. The motion you sent me was a motion to set aside the referee order. And so if you're gonna file a new motion before me, set forth all of that information so that we can review it and consider it. I don't know what you filed with the referee, so.
No, I'm talking about this motion, sir. It's on there, where I said I didn't get credit for 5 kids or health insurance. Like I'm looking at the motion right now. So that was one of my reasons for the objection.
Yeah,
Yes, sir.
well, we can bifurcate it and I could send it back to the referee on the issue of support. And then you would have to file your separate motion on parenting time. So it's up to you if you want to do that or just handle it all together.
I mean, I'll do whatever I need to do. This is like the first time I'm going through any of this stuff. So, I mean,
Yeah.
I'll do whatever I need.
Sir, your child was 3 in 2008. She's almost 18 now. Also, thank you so much, NPC gifting memberships. We do members only on Sundays around here. And yeah, he's got so many kids. All the bifurcations, which means to split it and send it back, I guess, or split it. This is just, he's just so late, Rachel, sort of like, no, I'm just joking. We don't late shame around here. We just ask that you hit the like button when you come in. I think that he is just literally a little too little too late. She's 18 years old in 3 months. It's almost a moot point, just like the judge said.
To do to make sure that the information is correct and the amount that's being asked for me to pay is correct.
Yeah.
And so yes, and so I got a letter last week, notice of redirection or abatement of child support, and so now they're saying that my daughter is not with her grandmother anymore and that she's actually back with Joy. And so they abated her mother and gave it back to Joy. And so it's a lot of things that's happening in a small amount of time. And it's inaccurate information. And so like I said, I'm not trying to not pay anything. I just want to make sure that all of the numbers is correct.
Okay, what I'll do is I'll refer the matter back to the referee to consider the second family deduction. And then anything else as it relates to parenting time, file your additional motion, okay?
All right, so parenting time motion and
Yep.
okay, I just want to make sure I write this down before I get off the phone with you.
Okay, well, write it down. We need to move on to another hearing, so do that, and the referee should contact you about, again, basically a supplemental hearing that relates to your other children, the deduction.
And the
Okay.
health insurance, yes, sir, and the health insurance too.
Well, I don't know what the referee's gonna do on health insurance, because, but I'll refer it back to the referee.
Okay, thank you, sir.
Okay, thank you.
All right.
I look like the referee today in my stripes. Oh, Judge, are you disappearing for a little while? Do you have something to do? Did anybody get anything cool on Amazon today? I just add things to my Amazon wish list. It's almost as cathartic as actually shopping, but much less detrimental. And totally possible. You can add anything you want to your wish list. I mean, you don't always get it, but we can all wish.
Please unmute.
No, I just muted.
Wesley?
Yes.
All right, Wesley, just letting you know, we do have 3 hearings scheduled at 10 o'clock. I'm gonna place you in the waiting room. Do not disconnect, okay?
All right.
Thank you. Lee Hansman?
Yes,
Okay. Are you here on the Hercules Materials versus Schaefer Ready Mix case?
I am. Yes.
Okay, and who are you appearing on behalf?
I'm appearing on behalf of Schaefer Ready Mix.
Schaefer Ready Mix, okay. Does Attorney Kleinman plan on appearing?
I don't believe so. No.
All right, so you're appearing on his behalf?
Yes.
All right, I'll place you in the waiting. Just so you know, we do have 3 hearings scheduled at 10 o'clock. I'll bring you in as soon as we're ready to call your case.
Excellent. Thank you.
This is the assistant's just like glory moment in the day, right? I think it's a cement case, you guys. I do indeed. Come on.
Which case this one?
Yeah, this
Get
is
your shit together. This is the ready mix guy too, or the other. Oh my goodness, Maya. Oh, what?
Please unmute. Attorney Snyder, please unmute.
Is the judge okay?
good morning.
7th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2023-2456 DC Dylan Luke. This is Mia Moore. Today is Monday, October 7, 2024 at 10 a.m.
Court will note the appearance of Mr. Snyder on behalf of the defendant. This matter is before the court on the defendant's motion to enforce and amend final consent order for custody, parenting time, and support. There has been an answer filed. Did you receive that, Mr. Snyder?
I did, Your Honor.
Okay. Now, as I read the pleadings, thought came to my mind is obviously exchanging the child at 12 o'clock noon does seem to present some problems. Why would it not be just easier to exchange the child at 6 p.m. rather than 12 p.m.?
I'm
That's our
totally,
position, Your Honor. And we're here on a continuance from last week, Your Honor. Plaintiff asked time to seek counsel. I received an email from who I believe is plaintiff's uncle on Wednesday saying that he met with an attorney, Tim Visser, on Wednesday, did not retain him, and his uncle tried to broker a deal as a non-attorney. I don't think plaintiff is taking this seriously, Your Honor, and I don't think he's giving respect to this court. I'm very frustrated with how this played out this past week.
Okay. Well,
What we would like, Your Honor, is a 6 o'clock exchange.
Your Honor, I object.
okay, sir, don't interrupt.
We would like a 6 o'clock exchange. Each party goes to the other party's house to pick up the child. Plaintiff's requesting a 7 a.m. exchange, which is unreasonable for a young child, Your Honor. It's just, it makes no sense. We're also asking all future communications to be through the MI Resolve family system through the friend of court, because there's a lot of harassment going on here, Your Honor, and my client does not deserve
Okay.
that.
Okay, Mr. Luke, what's your response?
Taking this seriously, 6 p.m. is still an issue. 7 a.m. or 7 p.m. would be more practical.
Why
Your
would
Honor-
six, why would 6 not work?
Due to my work schedule.
What time do you get out of work, sir?
So the reason why
Okay, that wasn't I asked you a question. What time do you get out of work?
so I deliver the mail for the post office, and I do not have a set time that I get out of work.
Okay,
Your Honor, can my client explain what happened on the Saturday, just this past Saturday, 2 days ago, the exchange?
no, I want to hear from the plaintiff and see what his response is.
Okay.
Mr. Luke, why does 6 o'clock not work? You could have, if you have relatives or et cetera, you could have somebody else pick up the child if that's the case, if you have difficulties on a particular night, but we've got to have an exchange time at some point.
Yes, Your Honor, 7 a.m. would work perfect for me so that I can pick up my child in the morning and get back to work on time. It's a 2-hour plus drive, and I start at 10 a.m. in the morning, and that is 7 days a week.
Okay,
So again, Your Honor, I would like my client to explain the exchange on Saturday, 2 days ago.
okay,
My-
well, let's kind of focus on the exchange time and see what works and what doesn't work there, because that sounds like that will take care of issues, hopefully, so.
Understood, Your Honor. This is a young child. 7 a.m. is very, very early for a young child to be woken up and transported several hours. It's not in the child's best interest at all. Like you said, plaintiff can have family members make the exchange if his work gets in the way for a given Saturday or a given Wednesday.
Okay,
You know, 6 p.m. is reasonable.
okay. Mr. Luke, could you have, do you have family members that are available or somebody that the child's familiar with and comfortable with that could handle the transportation in the event that you can't?
Your Honor, I do not. My family had issues with them dropping her off for me as it was. So that's why I'm trying to take responsibility myself.
And again, Your Honor, I would like you to hear from my client regarding this past week as well.
I'm not going to take testimony from your client, sir. Your representative, you can state what issues have to be addressed.
So Saturday's exchange, Your Honor, my client contacted plaintiff, arranged for a 12 o'clock exchange as usual. She arrived, he was not there. She contacted him. He said that his mother was picking up the child up. She contacted the mother. The mother had not even left the home. She was still an hour plus away because plaintiff told his mother not to pick the child up. This is what's happening, Your Honor, over and over and over again. Plaintiff is not taking this matter seriously. And it's affecting my client and the child, more importantly, the child.
Okay. Well, what I'm gonna do in this matter is I am going to change, I'm gonna change the pickup time in this matter. We'll change it to 6 o'clock PM from 12 o'clock noon. And we'll
And
have the exchange occur at the Speedway gas station in Portland. That's the halfway point. And what happens is if the parties have to wait 1/2 hour, that's appropriate for weather conditions, etc. If in fact the exchange, if the other party to pick up the child is not present by 6:30, the other parent can take the child up and have the child until the next exchange time, and they simply waive that particular time that they have. So, Mr. Luke, if you don't show up by 6:30 or have a relative or somebody familiar with the child to pick the child up, you waive your parenting time. That's the way it'll work. So,
Your Honor, would you entertain the requirement that all communication be through MI Resolve family system? These parties have communication issues, and I would like the court to, or the friend of court to monitor. So that if
I'm not gonna have the front of the court monitoring their communication. The court would, if you wanna have a place where the court would have access to, like our Family Wizard or App Close or something like that, I have no problem with ordering communication through one of those apps or something of that nature.
we would be acceptable to that, Your Honor.
Okay. Why don't we do it through App Close, because there's not the charge that there is with our Family Wizard. So state that the party.
Sort of like how the NPC just gave me a beautiful gift through PayPal, instead of YouTube Daddy, to avoid that 30% that YouTube Daddy takes. He doesn't deserve to be called Daddy, straight up. Sorry, YouTube Daddy, you don't. You haven't earned it yet. Thank you so much. Thank you. Hold on, I can actually say thank you. Thank you so much. I appreciate it so much. Yes, I completed a quest. Receive PayPal from NPC. Do. Love it. Thank you so much. Also, I love it, PayPal especially, because you get it right away. Thank you.
Would communicate through App Close, and that's how the communication would occur.
Okay,
Mr. Snyder, you can prepare that order and submit under 7-day.
thank you, Your Honor.
Okay, thank you. Free to go. Have a good day.
You too.
Your Honor,
Yes.
I would just like to state that 6 PM is setting me up to fail. Like, I have a job I have to provide for my child. That's why I'm requesting at 7 AM. Typical daycare.
We're not gonna do it at 10 AM. It's, the child would have to be up at 5 AM to do the exchanges, and it's just too early.
What I proposed is me driving the entire way at 7 AM because Mr. Snyder's client does not want to drive at that time.
Well, I've said that you'll meet at a halfway point. So you'll meet at a halfway point at 6 o'clock PM. If you can't do it, you'll have to get somebody else to handle the transportation, sir.
Thank you, Your Honor.
Thank you.
Thank you.
Also, where's the kid gonna go if he has to work 7 days a week and he's picking the kid up? He just takes this child on his mail route? Also, I'm not trying to be rude, but like, isn't that like a job that you can get, like, power through sometimes if they don't overload you and then be done early? Although not starting till 10 AM seems
Bradbury
weird.
Consman and O'Farrick.
Who's the second one?
Wait a second. He's a fucking Amazon driver. The Postal Service wouldn't have people working 7 days a week in a row. It's a union job, isn't it? Lisa, didn't you used to work as a postal worker? I swear to God we had a postal worker in here. Ed, hi. The only thing that I know that's delivered 7 days a week is Amazon. By their own drivers. Yeah, Figgy did, that's right. Lisa Fig, delicious. Anyways, the whole point. Post office sorting could be 7 days a week, but not delivery. No. Again, what are you talking about? What? You guys have jobs where they let them work 7 days a week straight? 20 fucking every day? Always? No vacation? No weekends? This is America. And these are my dreams, not yours. And you can shut the fuck up about it. And if you don't want the job, you can get out. Is that what they're saying? It just doesn't seem right to me. In Canada, you can't do that. Even if somebody wanted to. You could have multiple jobs and work your ass off. But legally, you cannot... I really don't think you can legally... There has to be hours between shifts. There's legalities. Also, you have to pay a lot more after a certain amount of hours. So all those extra hours that you're getting, that it's just cheaper to hire other people to work those shifts as opposed to pay the person OT to work it. I don't know. Maybe my Canadian's showing again, but it makes no fucking sense to me. If you work a job and you work 7 days a week and you're not on a salary that you're doing, what are you talking, 9 hours a day, 7 days a week? You have to pay overtime, right? Like, so you're again, you're compensating. What I'm saying is, like, it's just not a... I mean, here's the thing. I work 7 days a week a lot. Until recently, I started taking Saturdays off. Thank you so much. Welcome, Blue Strat dude. Like, a union would never allow that to happen here. It's just not good. It's also not good for your employees, right? Like, it's just not. But I understand sometimes when it happens. It doesn't sound sustainable to me. And it, again, if you're salaried, okay, but here in Canada, how it works is if you're a salaried employee, you're going to be getting paid a lot more than an hourly employee in exchange for that availability. But even that availability here, you're not expected to work 80 hours a week. It's just not. Also, that buddy there that said I object twice, that doesn't understand it, he ain't working in no high-end management job. I'm sorry, he's not. So I would doubt that he's a salaried employee.
Hansman, Bradbury, and O'Farrick.
Bradbury, who?
Hansman.
And here are
Hansman.
lawyers, they charge for every
O'Farrick.
6 minutes.
Okay. So some of the other people have gone by the wayside.
Well, it looks like Bradbury is appearing on behalf of Attorney Nichols, and Attorney Hansman is appearing on behalf of Attorney Kleinman, and Attorney O'Farrick is...
So Attorney Fafaric, why do you not have somebody else appearing for you? Then we'd have a trifecta here.
He's muted. Please unmute.
I'll go find somebody, Your Honor. Hold on.
Okay.
Okay. Calling case 2024 549 CB Hercules Material Holdings LLC versus Atlas Concrete LLC et al. Today is Monday, October 7th, 2024, at 10:11 a.m.
Court will note the appearance of Mr. Bradbury on behalf of the plaintiff, Ms. Hansman on behalf of defendant, Mr. Fafarik on behalf of one of the defendants as well. This matter is before the court on the defendant Schaefer Ready Mix's motion to strike plaintiff's second amended lay an expert witness list and first amended initial disclosure. Ms. Hansman.
Thank you, Your Honor. Good morning. As you may recall from the last time we were before this court, this matter relates to the plaintiff's lawsuit against Mr. Fifarik's client, Mr. Kelly, and my client, Schaefer Ready Mix, relating to claims that we interfered with their contracts and their business expectancies. Mr. Kelly came to work for my client, and they're alleging that we interfered with their business expectancies and contracts thereafter. This case has been going on for some time now. I think we transferred to Calhoun County over a year ago, or close to a year ago. Early on in the case, the plaintiffs named an expert witness that they alleged was going to support their claim for damages relating to these contracts and these business expectancies. And both Mr. Fifarik and my office sent a lot of discovery trying to understand the basis of those claims starting back in March. We asked quite a bit about damage and what they're going to allege or prove as far as damage. And the response we repeatedly got over and over and over was refer to our expert, talk to our expert, et cetera, et cetera. We saw that as non-answers, had to come before this court and file a motion to compel, which you granted, and told them that you need to file some complete discovery responses and your expert needs to prepare a report that has to be filed with this court in early July. So that happened, sort of. They did file an expert report. The report contained nothing of substance. It said, I can't tell you anything until they give us all their confidential business information. So it was kind of a non-report. We sent some follow-up requests to try and figure out what we need to do here. And the long and short of it is they decided to subpoena all our customers and try to get some confidential business information to prove their case, which again forced us to come before this court on a protective order hearing. You may recall that we were here and you granted that protective order and said, look, you have to identify the relevant customers and contracts that you're filing this lawsuit about. You can't, do this in reverse. You have to identify those. And once you've identified the relevant customers, we'll go from there. Well, as it turns out, you quashed those subpoenas, but they never actually withdrew them. First thing, which I only learned in the past week. So they never withdrew their subpoenas, got a bunch of confidential business information they shouldn't have, which some of which they had before we were before this court last time and didn't disclose. So here we are. We're now through mediation. We're through case evaluation. All of the remaining depositions in the case have been scheduled. And in fact, all but one of them have now been conducted. And the day before we had scheduled the deposition of their expert witness, Suzanne Tarchula, we abruptly are told they're canceling that deposition and they're withdrawing her as a witness. Keep in mind, we had 4 days of discovery left when they did this. We're told at the deposition of our client that they're going to prove their case through their business principal, Mr. Stamper. We think no harm, no foul. Mr. Stamper's deposition is scheduled. So we'll just take his deposition and we'll get to it through that. Well, we have his deposition, Your Honor, and he knows nothing. He says he can't speak to damages. He doesn't have that information. He doesn't know it. And when he's pressed on those questions, his answer continually, probably 5 or 6 times was, well, discovery's not over. Well, there's 4 days of discovery left and there was no outstanding written discovery at that point. So I'm not sure what they thought they were going to prove through discovery. But once again, here we are trying to defend this case and we don't know what we're even defending against because there's no claim. Now, here we are today, October 7th, discovery is now over. The depositions have been taken with the exception of one that we rescheduled at the plaintiff's request post-discovery. But other than that, discovery's finished. We've asked for everything. And what's going on here is we're having this last minute scramble of, oh, well, I guess since our witness didn't know the answer, we better file an amended witness list and amended disclosures and try to get a new witness that's going to testify to damages. So at the 11th hour, very, very end of discovery, we get this amended witness list and amended initial disclosure, and they've identified their new damage witness as their in-house accountant who's been around the whole time. If they intended to use him to prove their case, they could have named him since day one. This is not a new surprise or witness that they couldn't have previously produced so that we could have done discovery as intended. So at this point, Your Honor, I'm forced to file this motion saying This is not appropriate litigation. This is sandbagging, and I would like to ask that the amended list be stricken and that the new witness not be permitted to testify.
Thank you.
Sandbagging means something different in car sales. When I sold cars, sandbagging was what the managers did with deals during the week, because on Saturdays they would buy lunch for everybody if you sold like 3 cars before noon. But feasibly, it's actually impractical to buy lunch for like 45 people on short notice. So the managers understood that, and for morale, they wanted everyone to have lunch anyways. And so we just like, they would sandbag deals. So they would be like, oh, we're gonna hold on to these until Saturday and then book 3 easy deals first thing in the morning so that Paisley can order the proper lunch. And we would all get lunch. And sometimes I'd order it the day before because I was pretty confident I would know we would get these deals. So that way I could get like good food, proper catered, instead of just like Subway or shit, whatever that is quick.
Mr. Paparik, any response, or you just
No, if I may, Your Honor, thank you
Go
very
ahead.
much. And we join in and concur in the relief requested. Throughout this matter, you know, last time we were here, we talked about fishing expeditions. And today we're talking about hiding a ball. I'm not really sure what plaintiffs are attempting to do throughout the course of this litigation, other than they don't like the idea that Schaefer is out there in the same industry that they are in. But so as counsel pointed out, we've been trying to find out since March of this year as to what their claim for damages is or would be. And they eventually articulated their position as that they were entitled to lost profits based upon sales that they, Hercules and Atlas, would have realized but for the wrongful conduct of Mr. Kelly, Defendant Kelly, and Defendant Schaefer. And that's what they told their expert apparently to go out and base their opinion on. And that's what the expert opinion, to the extent that there was an expert report presented by the plaintiffs in this matter, said their case was all about. Now we come to the end of discovery and there are no lost sales. Mr. Kelly nor Schaefer have done anything to interfere with any contract or proposal or bid that Hercules thought was theirs, or Atlas thought was theirs, or that they could have obtained. And so they withdraw their witness and they come up with this new remarkable theory of damages called operational damages. First time we hear about it. Last week of discovery. They even take the time to try to amend their disclosures and say, here's our claim as operational damages. But they don't take the time, nor the effort, nor the ability to explain what operational damages are. They haven't qualified it or quantified it, given any basis for it, nothing whatsoever. Nothing that we would have done through the entire course of a year plus of discovery to try to find out what their claim was. So they're either hiding the ball or they're trying to keep a case alive that shouldn't be alive anymore. So let's go back to where this should be. It shouldn't be Schaefer, it shouldn't be Kelly coming before this court with a motion to disallow an amendment to a witness list. It should be the plaintiffs here with some good cause, some basis where they should be able to amend their whole theory of their case here at the 12th hour. And they haven't done that, and they can't do that. As counsel pointed out, this is their own employee. This is their own in-house accountant. This is nobody new to them. These are not new concepts, if they in fact do exist. They're simply trying to keep a case alive and they shouldn't be entitled to amend anything at this point in time, Your Honor. And we ask that the relief requested be granted. Thank you.
Okay, thank you. Mr. Bradbury, your response.
Yeah, good morning and thank you, Your Honor. I guess broadly, my response to what Mr. Pfeifferich was just discussing is that the rules require the plaintiffs to affirmatively amend under these circumstances. And I don't agree with the.
I'm sorry, I was dealing with a laundry issue in our house. You know how families are. Somebody, but there's a rogue pair of underwear in the house. Most often I deal with lost items. This is an extra item. We're not quite sure whose underwear they are. Oh, hi, Loud. I haven't watched Matt today because I haven't worked out yet, but I'm going to tonight.
Characterization that Hercules complying with that obligation is somehow hiding the ball or trying to affect some last minute change to the nature of the case. I think more accurately, the circumstances here reflect that through the course of discovery, new information was gathered. Certain restrictions were placed upon Hercules in terms of what was and was not fair game, in terms of what they anticipated was going to be a lost profits case. And I agree with Ms. Hansman that the discovery protective order that the court put in place in late July, early August was an important, I'll call it sort of a turning point in how the case unfolded from there. And what happened was after the court granted that protective order, a new round of written discovery took place. And Hercules served interrogatories and document requests on both parties, but most pertinent here onto Schaefer. And in doing so, attempted to gather some of the information that would be required for it to determine which customers, if any, were sort of fair game in terms of conducting a lost profits analysis, which they had been telling, Hercules had been telling the defendants in this case all along, that, you know, it is sort of an unusual case in some respects in that, yes.
Hi, Christopher Angleby. Be safe where you are. Also loud. That's hilarious. I love it. You know it's not the truth. Hey, hey, baby. Hey, hey. That's a good idea. Okay, and you're broke down and you gotta walk. You need to get 2 miles. How many kilometers is that? Is it possible to walk? I know. Maybe it's not. I don't know. I hope it works out, reseller.
We needed some information from them about their customers and sales in order for our expert to conduct that lost profits analysis. Now, the discovery rules, of course, afforded them 28 days to respond, and they took all 28 days to answer those interrogatories, as was their prerogative. Of course, they knew that taking all 28 days would sort of put us in the bottom of the 8th inning.
Well, now I look like a real asshole. Thank you, Cellulite Yoga Pants, but it's regardless at this point because basically it's a real dick. I'm sorry, reseller. Well, fuck. You're road tripping with your mom and dad? You're not near reseller, hey? I don't think so. Oh. I don't know what to do about that. My brain's drawn a blank. Down in Texas, I know there's not a lot of public transit down there.
If you will, in terms of where we would be in discovery. But nevertheless, they did. And when they did, the long and short of it was that they took the stance, and not surprisingly, and I believe that they would, you know, tell the truth in sworn interrogatory answers, that essentially there would be no customers who are fair game for a lost profits analysis. And so there, and that specifically occurred on September 19th, Your Honors, when we received those interrogatory answers. So September 19th, Hercules receives and assesses those interrogatory answers. Thereafter, as Ms. Hansman explained, there were some depositions that were scheduled, including Mr. Stamper's deposition, in which I was not present, but my understanding is that he was not aware of the particulars about the sorts of operational damages that Hercules suffered, but indicated that discovery was ongoing, that Hercules would identify who, if anybody, would be an appropriate witness with knowledge about those things, those topics. And that's what Hercules did. So that by less than a week later, on September 25th, Hercules goes and, in accordance with Rule 2.302E, supplements its earlier disclosures to remove the formerly identified expert, since this was no longer going to be a case involving expert calculations of lost profits, and to identify the fact witness in question, that is an accountant employed by one of Hercules's sort of sister entities, an accountant named Stuart Moore. So the rules required an affirmative supplement, which Hercules did in a timely manner, again, September 19th to September 25th, and that identified this fact witness who would have knowledge about the topics that Mr. Stamper did not have knowledge about, excuse me, during his deposition. So I would say that in a circumstance like this one, where the party complies with its duty to supplement, that would not be an appropriate circumstance where a sanction such as the one that the defendants are asking for would be appropriate. And then the last thing that I would add is that despite the fact that we were in the bottom of the eighth inning and now discovery is closed, there really is no prejudice to the defendants in this case, where we're talking about one additional witness, and where we have said and where we maintain that we would not object to the defendants deposing this witness, and it would not require extending discovery. It would simply require an agreement or an order permitting them to do so outside of the discovery window. So unless the court has any questions, those are my that's my response.
No, I have no other questions. Obviously, you've supplemented, but the court will note that does not modify the case scheduling order that this court put into place, and that cannot be again changed without proper motion, etc. The court will, in this case, enforce prior orders, and if the disclosure did not again comply with the prior orders of the court, and the party seeking to change that did not seek amendment and provide a substantial reason for doing so, the court will bar those particular witnesses, or witness or witnesses, whichever the case may be. So again, Mr. Bradbury, if you want to change your witness.
Oh, I'm sorry, that's not funny, but it is funny. Are you guys in the Discord? Sometimes that's the way to get in touch. Cellulite Yoga Pants should be able to drop a Discord link now. You might have to do a new invite, Cellulite Yoga Pants, but you have the permissions to do that. Yeah. Judge denied. Interesting. So they were playing around, and I think it might just be an old Discord link. You might have to literally go into Discord with your Discord powers and try that.
List, and you have an affirmative obligation to file a motion and do so in this matter. But at this point, the court's going to grant the defendant's motion to strike any supplemental or amended witness list that does not comply with the prior orders of the court. So that will be the order. Ms. Hansman, you can submit that under 7-day notice.
Thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Have a good day.
And thank you again, Chris. I hope you have fun in Galveston. I got married in Galveston. Also, you're doing all the driving. Oh, please be safe. Please be safe. Go to sleep. Have a good sleep. Enjoy your trip. I want to hear about where you stop tomorrow. Also, yes, we posted that Discord link there if you were wanting to connect. NPC and reseller road trip. That might be a good way to do it.
Good morning. Your first and last name, please. Motorola.
Danielle Harrell.
Motorola.
Harrell.
Harrell. Yes, ma'am.
MOTO. Hello, Moto.
Danielle, I'm going to place you in the waiting room. I will bring you in when we're ready to call your case, okay?
Okay, thank you.
Okay, we do not have plaintiff Chloe Meisner present. Calling case 2024-1741DS, Chloe Meisner versus Wesley Snyder. Today is Monday, October 7, 2024 at 10:28 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to set aside referee order in this matter. Mr. Snyder, you can proceed.
So, when I got the child support order, I looked it over and it said that I have my son Grayson James Schneider 76 overnights a year. But when I did the math, I have him a minimum of 128 overnights a year.
Well, as I read through the motion, Mr. Snyder, the court came to the impression of saying, how's the court to know that you didn't supply a transcript or anything else other than your bare allegations? So how's the court to know what the referee based that on if I don't have any record?
Yeah, I did put a bunch of my check stubs since April on it and did the 2 overnights every week times 52 weeks a year, and then the extra days a month, and got 128 days.
Okay. It still doesn't show me what the testimony was at the referee hearing or what the referee decided the information on. So I can't say that the referee made a factual or legal error if I don't know what the referee decided the case on. Well, let me hear from Mr. Magnuson. Mr. Magnuson?
Yes. I can only indicate from my notes, Your Honor, that the referee, the income that was attributed to Mr. Snyder was based on his job at Phil Walters Auto. The referee used $17 an hour for 42.5 hours per week on average. Basically taking the regular income that came to $2,958 per month with the average overtime taking it up to $3,235 per month. So that was what was included. It was, and I would note that both parties were present and did provide testimony, and that's what Mr. Moeller based his finding on, the testimony of the parties and Mr. Snyder's testimony as to his work at Phil Walters.
Okay. Mr. Snyder, any response to that?
Nope, I don't have anything about that. It was my main concern was mostly the overnights.
Okay. Well, what you're gonna have to do, sir, is you're gonna have to order a copy of the transcript and provide that to the court. That's the only way the court can review and see what the referee had to look at as far as testimony to be able to make his decision in this matter. So what I'll do is allow you to have time to get the transcript. Once you get the transcript, you can renew your motion and reschedule it, renotice it at that time after the court would have an opportunity to review it.
Okay. And would I be able to get that down at the courthouse?
Yep, you can make a request for that through the referee through the front of the court and get a hold of a copy of that transcript.
All right, thank you.
Okay, thank you.
Thank you, Your Honor.
Yep, thanks.
This case is Danielle Clark versus Reginald Shelley.
I thought they both had the same first name.
Reginald in the waiting room. Mark, I'm gonna have to put you back in the waiting room, okay?
Not your turn, Mark. Go away. Also, it's cold. And I don't want to go to the gym, but I'm gonna. Actually, I do want to, but I don't want to walk. But
Marchene Clark McClam versus Devin Carlucci. Nope. Ashley,
Yes.
what hearing are you appearing on this morning?
So I am here for Clark v. Shelley. Supposed to be a 10:30 motion hearing.
And you have Reginald?
Yes.
So I'm gonna put you in the waiting room and bring you in just a few minutes, okay?
Okay, thank you.
Marchene? Please unmute. Is it Devin?
Yeah, it's Devon.
Yvonne, okay. Marchene, can you hear me?
Yes.
Okay, calling case 2023-1731 DS, Marchene Clark McClam versus Devon Carmucci Sr. Today is Monday, October 7th, 2024 at 10:35 a.m.
This matter is before the court on the defendant's motion to set aside default and or default judgment. Mr. Carmucci, you can proceed.
How you doing, Judge Kirkham?
Good. Go ahead.
Once again, we're here. I'm gonna try to keep this short and simple. I don't have a good relationship with my 3 kids with Marchene. I don't have an emotional connection with them as my other kids. They don't look nothing like me. And I'm asking you to grant me a genetic test for Kaz and Charlie. Just for the sake of my mental health has took a huge decline with best friends, relationships, my job, because of this situation with Marchene. So I'm just asking for a genetic test so we can move forward.
Okay. Well, sir, in this matter, you moved to set aside the default and default judgment. You didn't mention anything in that about any DNA test.
Correct.
Okay. Well, you just can't come to a hearing and bring up new issues that were not pled. The matter is before the court on the motion to set aside default and default judgment in this particular case. There's different requirements if you are going to contest paternity, and you'll have to file a motion to contest paternity, setting forth factual basis as well as the legal basis for your motion, which is different from this motion. So you can't come in again at the time of this hearing and change why we're here because you came up with a different idea.
Okay. I had a situation with another woman by the name of Caitlin Rose. Same
Okay.
situation.
I don't care about any other third parties. That's not an issue here. Okay, we're dealing with Miss Clark in your case, and that's it. Miss Clark, do you have anything to add in this matter?
No, I don't. If he wants to do a DNA test, I would rather him do all three of my children instead of just the two.
Okay, well,
Me too.
But
okay. Well, in this matter, again, the parties can do what they want. If you want to submit the DNA test, that's fine. In this matter, though, the notice of hearing for entry of the default judgment was sent at least 14 days prior to that hearing. Michigan Court Rule 3.210 parens 6 parens A provides that the motion to set aside the default judgment must be filed within 21 days after the default judgment was entered, and if there's good cause shown. In this case, the judgment was entered back in October 10th of 2023. Clearly, you've missed the 21 days in this particular matter, and you've not shown good cause. The court will deny the request to set aside the default judgment in this matter. If you wish to address paternity, you can, if you get agreement with Ms. Clark to do so, you can do that, or otherwise you'll have to file a motion to do that, sir.
Okay, so I have to
we're
find
in
another.
agreement. How do we go about that? We have to do that separately from right now?
Yep, you'll have to do it separate from this because I don't have that motion before me.
Okay.
I mean, if the two of you agree and you want to have DNA testing done on your own, you can do that. But there's no basis for the
I'm not
court to
going for it.
order it because I have no motion before me asking for that.
That's
I'm
what I
sorry,
was
Judge.
wondering
This is
when
the
this got
only.
sent out.
That's the only motion that I could find that could help me. I didn't know there
Well,
was a motion for the paternity, so
yes,
I'll
there
agree on
is.
that.
There is. You can get on any of the sites like MichiganLegalHelp.org. They have all of the paperwork at that site for, again, for setting aside paternity, and you'll have to file that, but this isn't the appropriate motion for that. So court will deny the motion to set aside. Ms. Clark, I'll ask that you would do an order setting aside or denying the motion to set aside the default judgment, and you can submit that under 7-day notice of entry. That will be the
Okay.
order of the court. You're free to go. Have a good day.
You too. Thank you.
Yeah.
Ain't no way she's filing that motion.
Danielle Clark versus Reginald. Danielle,
Yes,
are you formally Danielle Clark?
yes, ma'am.
Calling case 2012-3371 DP, Danielle Clark versus Reginald Shelley. Today is Monday, October 7th, 2024 at 10:41 a.m.
Court will note the appearance of Mr. Robinson on behalf of the plaintiff, Ms. Smith on behalf of the defendant. This matter is before the court on the plaintiff's motion to change custody. Mr. Robinson.
Thank you, Your Honor. As I stated last week, we have a situation where Mr. Shelley had physical custody of the child until last August, when he committed a rather serious assault against the child and was charged with felony child abuse. Last December, he pled guilty to third-degree child abuse and was placed on a 1.5 year probation. condition of which he was to have no contact with the child. He has since been released from that probation and wants to return to the situation as it existed before before the criminal charges were brought. He's had no contact, significant contact with the child since last August. There was no juvenile court intervention, so there was no reunification plan. And what the plaintiff is asking is the court set a brief evidentiary hearing so we can establish that the facts we've alleged for the record. And we'd also ask the court to interview this child who will be 13 in a couple of months.
Okay, thank you. Ms. Smith, what's your response?
Yes, Your Honor. So my client, prior to the assault charge in August of 2023, was granted sole physical and legal custody of the minor child. The plaintiff was out of the state of Michigan and out of her child's life for whatever the matter may have been for 6 years. We would argue that there has not been a change of circumstance, especially since when the incident happened with my client, the child was removed from his care and was to be placed with his aunt and uncle. And the plaintiff came in and removed the child without CPS's permission from the home of his aunt and uncle. My client also signed a power of attorney for the child to go be with the aunt and uncle. Mom came in and removed the child when she's not supposed to have any contact herself with the child due to CPS. So we would argue that there has not been a change of circumstance for to grant an evidentiary hearing in this matter.
Okay, thank you. Well, in this particular case, the court does note that obviously there's substantial allegations in this case. And again, those are substantiated by the fact that the defendant did plead guilty to child abuse fourth in this particular matter. The court does believe that the Vadbarka threshold has been met for an evidentiary hearing. The court is going to refer the matter to the referee for an evidentiary hearing. And further, in view of the assault, which the defendant pled guilty to, the court will suspend parenting time until the referee makes a determination after the evidentiary hearing. So court will do the order of referral in this particular matter. And Mr. Robinson, if you would do the order as it relates to suspending parenting time pending that hearing.
Okay, thank you, Your Honor.
Okay, thank you.
Ms. Smith,
Your Honor.
Ms. Smith, are you with legal aid?
No, I'm not. I'm retained.
Okay. I can look you up then and know where to send the order.
Yeah, I did send you an email, but yes, you can look me up.
Oh, okay.
Yep.
Thank you.
Okay,
Thank you, Your Honor.
Free to go.
Thank you, Your Honor.
I'm listening to music, so I can't talk.
We have Michael Meese. We do not have plaintiff.
We have what? Which one?
Michael Meese. We do not have Caitlin Apsey.
Oh.
Michael, please unmute.
Hello?
Hello. Calling case 2024-1069 DS, Caitlin Apsey versus Michael Meese II. Today is Monday, October 7th, 2024 at 10:46 a.m.
Court will note in this matter that this is before the court on the defendant's motion to set aside referee order in this particular case. I guess I have a question, Mr. Meese. I don't understand in this matter. If I reviewed the referee's order, it stated in that order that that order was by consent of the parties that order being entered on September 10, 2024. So I'm in a bit of quandary. How could the referee make a factual or legal error if in fact the parties consented to the order?
At the time, yes, I did consent to it. And then I did some more digging and I didn't feel like I was able to say everything I needed to say the meeting prior to that.
Okay, well, let me tell you, when you consent to an order, that's the order. And the motion to set aside the referee is not the proper method to proceed because the referee didn't make a determination. So you can't allege that the referee made a factual or legal error when the referee simply affirmed your consent and your agreement with the other party. So the court doesn't find any basis to grant your motion to set aside the referee because it was a consent order. So the court will deny your order in this matter. And if you have another basis at some point, you can always file a motion, but this isn't the proper motion to file.
Everybody that I talked to at the courthouse, the circuit court, said that I could file against that.
Well, I have no idea what they told you, but again, if it's a consent order, to set aside the referee order, you have to show that the referee made a factual or a legal error. Well, when you consent to it and you put an agreement on the record, the referee isn't making an order. The referee isn't making a determination. He's only affirming what you agreed to. So it's not a proper means to set aside the consent order. So court will deny your request, sir.
I didn't know that I couldn't consent to it. I'm sorry.
Okay, well, I can't deal with that. I'm just saying it's not a proper motion in this matter. So I'm denying it.
One thing I did agree to that did get changed was he said child support wouldn't change and the head of household wouldn't change at all. And both of those have changed.
Well, all I can say is that, again, it was a consent order. That's it. I've denied the request. And if you have another basis to proceed, you'll have to file a motion and do so. Thank you, sir. You're free to go.
Like, bruh, you need a lawyer. He was super mad. It's too complicated. It is too complicated for most of us to do. Even at, oh, okay. Daniel, Mr. Butcher.
PPO hearing. Please unmute, Daniel.
Yes, ma'am.
Okay, are you here for a PPO hearing this morning?
Correct.
Okay, I'm gonna place you in the waiting room. We're still working on our motion hearings.
Okay, thank you.
Thank you.
Well, thanks, Katrina, or whatever the fuck your name is, for that anticlimactic ending. But that is the ending nonetheless. Thanks for liking the video, Kimby. I appreciate that. It actually really helps with YouTube, Daddy. I hope that you guys had a nice evening. I certainly did. I want to send really positive vibes to everybody across the world. But seriously, in Florida and reseller road trips, please be well. All our Florida family, please check in tomorrow. I will be back in the morning, and I will be cooking something. I think, I don't know what we'll do. Oh, let's just do pancakes. We might just have pancakes in the morning. I appreciate you guys so much. I gotta get to the gym. I don't want to, but I'm gonna. Y'all have to follow up with me tomorrow. This lazy ass is going to the gym. I hope that you have a wonderful night. Remember that I love you. I'm proud of you. And I will see you in the next video. Bye.
Ways down and ready to ride.